campaigners have won a legal challenge against plans by the Scottish Government to assign every child in Scotland a named person, such as a teacher or a health visitor. The government insists its plan would make sure every child gets help and support, but critics say it intrudes into family life.
We had a letter from NHS Forth Valley Trust over 2 years ago, which got us involved in this scheme, saying that our child's confidential medical records would be shared, and if we failed to turn up to appointments, then our child's named person, who we didn't know who that was, would be notified of that, and that that could come back, as it were, to bite. So yes, we've been involved in this campaign and the court action from the get-go.
What we have to now do is to look in detail at the Supreme Court judgment and the specific requirements to improve the way in which data is shared between professionals as they support young people within Scotland. That's the only issue that the Supreme Court has found that we need to improve as part of the case that they have considered. They have viewed the policy aim to be legitimate. They recognise the compatibility of the legislation with EU law, with the exception that we've got to clarify the data sharing arrangements. So I'm now going to take forward a piece of work to do exactly that, to look at the improvements to the data sharing arrangements, and I'll report fully to Parliament about how that will be taken forward as we implement the named person legislation.
Joining us now live from central London is the campaign spokesperson for the No to Named Person scheme, Simon Calvert. Hello to you, Simon. Thanks for joining us. Look, I'm trying to look for the positives in this, and it could be seen as a scheme to protect youngsters, couldn't it?
Yeah, nobody would object if they simply brought forward a scheme in the way that they describe it, which is a voluntary scheme whereby parents have a single point of contact, if they want one, to help them access services. And that's how the Scottish Government has tried to describe it, but that's not what they legislated for. What they legislated for was somebody who has a legal duty to monitor the well-being of children, and this is for every child in Scotland, regardless of need. They said that well-being means happiness, so these are people monitoring children's happiness, not their welfare, not their safety, not risk of harm, their happiness. And they gave these people, these named persons, very extensive data sharing powers to be able to obtain and share private information about families at a very low threshold without the families even knowing about it. And that's what the court has struck down. So those data sharing powers, those snooping powers, were at the heart of the named person scheme, and the Supreme Court today has said that those powers are a breach of human rights. That's a very serious ruling. That's a very worrying ruling for the Scottish Government.
What about looking at it from the child's perspective, though, and the fact that some children literally have no one to turn to, no one to talk to, and that's why organisations like Childline have been set up. To what extent would they have benefited from something like this?
This wouldn't help them. This is not the solution to that problem. There are good teachers, good health visitors, others in the lives of children and young people who know how to recognise signs of when a child needs help. The named person legislation is not the answer to that problem. To say that there is a person, a teacher or health visitor who probably is not known to the child or their family, who has legal duties and legal powers to find out information about them and share it round, actually puts families and young people off accessing services. One of the parties that intervened in support of our legal action is called Clan Child Law, and they were concerned about the fact that children and young people who learned that named persons would be able to be ordered to share information that they gave in confidence to service providers, the fact that that information will be then shared around other agencies, they said would put children off accessing services. Confidentiality is very important, and the named person legislation just ran a coach and horses through people's confidentiality, and that's why the court struck it down.
Okay, Simon, as far as the government, the Scottish Government is concerned, they say that they are going to try to adapt this and then push forward again. What changes would have to be made in order for you and others like you to be happy?
Well, what the government needs to be most concerned with is what will make the Supreme Court happy. There's an 80-page ruling here which invokes the crucial importance of allowing families within limits to manage their own affairs one that even invokes the spectre of totalitarian governments indoctrinating children. It says that the data sharing powers were a breach of human rights. It says that the legislation was defective, that it was confused. It talked about arbitrariness. The Scottish Government has to legislate in a way which gets around all of that and answers all of those questions. And that's not going to be an easy task.
Okay, great to talk to you. Thank you.